And sometimes good things come in twos. We got two federal judges back to back in the District of Columbia who've ruled against Donald Trump and have ruled that certain types of information have to come forward about the role Elon Musk and DOGE is playing in the federal government. We all see it with our very eyes. Him slashing and burning, him destroying worlds of funding and federal workers. And now Judge Chutkan, in a new order, has just allowed a group of 14 states to obtain some limited discovery about Elon Musk and his role in order to support a preliminary injunction and trial of theirs. The judge has done a deft job of working her way through executive privilege, but she's going to allow the discovery because it's important, imperative that people know the role that Elon Musk is playing, and discovery under a judge's watchful eye can determine it and suss it out. I'm Michael Popok. I'm going to suss it out right here on Legal AF, the YouTube channel. Brand new order just came out with Judge Chutkan. Let me get to the heart of it. Judge Chutkan, as you may recall, presided over many aspects of Donald Trump's criminal prosecution in the D.C. election interference case. She's well steeped in all things Donald Trump. She learned at the knee of Donald Trump, if you will, and all of those Jan 6 cases that she presided over. And of course, the ultimate case brought by Jack Smith against Donald Trump for election interference was in front of Judge Chutkan. But this is the case of the state of New Mexico and 13 other states against Elon Musk and DOGE. Now, earlier today, I did a report about an order coming out from Judge Cooper in the same courthouse in D.C. He ruled earlier today in his case that the DOGE and Musk were subject to Freedom of Information Act requests. They were an agency or a quasi-agency. They weren't an advisor to the president. They were not able to hide their communications and their documents behind the smoke screen of executive privilege. That was his case. This is Judge Chutkan's case. Here's how she has ruled. And what she said ultimately is, I'm going to find that I have jurisdiction, even though the issue of whether the states have Article 3 standing to be in my courtroom is still up for grabs. They need discovery in order to establish it, and I'm going to allow it. I'm going to allow limited discovery, not to get behind the veil of executive privilege, but to get to the bottom of Elon Musk's role. I'll let them develop it. It's a very, very surgical set of discovery requests. Discovery being that period of time after the filing of the suit, during hearings or in support of motions and in advance of a trial, that the parties exchanged information and documents. You do it through a request to produce, a request you send to one side or the other, asking them to produce documents. That's a request to produce. You do it through an interrogatory. That's a question under oath that needs to be answered. We call that ROGs or interrogatories. You do it under a different type of device called a request for admission, where you set down a statement and you ask the other side to admit or deny it. And then, of course, you have depositions, which are a question and answer live under oath as if you're giving testimony in the court of law. Here, the plaintiffs have said we only need 5 requests to produce categories, 6 interrogatories, 6 requests for admission, and 2 depositions. And then I got to tell you, you get at least generally 25 of everything in federal court, just to round it off. So they're asking for 5, 6, 6, and 2 depositions. So let me cut to the chase. The judge said no on the depositions for now, and no on the request to produce and interrogatories going to anyone but Elon Musk and DOGE. In other words, not to Donald Trump, the president who's been sued as well, not for now. But otherwise, it looks very well tailored to me. Here's what the judge said, starting on page 7 over to 9, about how we got here. Page 7 at the bottom, the requests target information relevant to plaintiff's claims for injunctive relief, with a few adjustments. Plaintiff's documents seek information regarding DOGE's and Musk's involvement in 1, eliminating or reducing the size of federal agencies, 2, terminating or placing federal employees on leave, 3, canceling, freezing, or pausing federal contracts, grants, or other federal funding, and 4, obtaining access, using, or making changes to federal databases or data management system. Evidence that defendants eliminated agencies that work with plaintiffs, the the states, terminated employees responsible for managing programs with plaintiffs, the states, or canceled contracts with plaintiffs is relevant, the judge went on to say, as to whether defendants exceeded their statutory and constitutional authority. In declarations, that's on page 8, in declarations accompanying plaintiffs' temporary restraining order motion, they identify the federal funds, agencies, and contracts the plaintiff states relied on and the harm that would result from pausing or terminating these resources. To accurately tailor the request, the court will adopt a narrowing principle. Plaintiff's request shall be read to encompass only information regarding agencies, employees, legal agreements, or data management systems that involve or engage with plaintiff states, including entities or institutions funded by plaintiff states. Again, subject to a minor amendment, plaintiffs, the judge went on, have sufficiently tailored their interrogatories, that's the questions under oath, and requests for admission. Those requests seek to identify DOGE personnel and parameters of DOGE's and Musk's authority, a question central to plaintiff's claims. Let's stop right there. That means the judge is going to allow them to ask the question under oath, what is Musk's role? What is his authority? What are his powers? Same for DOGE. Answer it under oath, under penalty of perjury. That's a big news. That's the first time Elon Musk will be required and compelled under penalty of perjury to answer a question about his role. Not a press conference, not a speech, not a social media post, right? Not off the back of his ass, balls of his butt, but in a court document. That's going to set up the fight with Donald Trump taking Judge Chutkan up on appeal to the D.C. Court of Appeals, D.C. Circuit Court of Appeals, arguing that executive privilege has been violated. But I digress. Let's continue. That's a big, important thing, by the way. If we ever get Elon Musk in a deposition, which the judge says not for now, let's start with your interrogatories, the least invasive of mechanisms to obtain information and discovery first. On page 9, the court says, I'm going to tailor this so that advice giving between Trump and Musk is not implicated. They're not looking for communications or emails. And I'm going to carve that out of the request. The judge says on page 9, as written, it asks defendants to identify in the interrogatory federal agencies where DOGE personnel or Musk recommended cancellation of federal contracts or termination and when such action occurred pursuant to the recommendation. The court will strike recommended and recommendation and insert directed and direction. That said, this way she's getting out from under the advice-giving component of a possible executive privilege problem. That said, defendants may not creatively interpret the interrogatories to circumvent the discovery obligations. In other words, I'm watching you, Musk. I'm watching you, Trump. And then she goes off to talk at length about why she doesn't believe that the separation of powers or the executive privilege issues have been violated. As to the Article 3 issues of standing, whether these parties have standing or injury to pursue the case, she said, yeah, that's part of what the discovery is about. And I currently have jurisdiction in a case or controversy to give the other side limited discovery in order to support their standing argument against the motion to dismiss that's coming from Donald Trump and from the Department of Justice. So there is a motion to dismiss that's being briefed. The judge says, we'll get to it. We're going to allow discovery to go forward first. And she said, I'm going to collapse, as I expected, the preliminary injunction hearing and the final trial on the merits. Now, just to back up for a minute, this judge in this case about 2 weeks ago denied the temporary restraining order sought by the 14 states to stop DOGE and Musk from continuing their rampage through federal funding and federal workers, because she found they did not sufficiently state irreparable harm, and because they couldn't link why this has to be stopped now. Doesn't mean she's not on the merits of the case, at the trial of the case, without the extraordinary relief of temporary restraining order, that she's not going to grant and fine for the permanent injunction. It just means at that moment she wasn't ready to do the preliminary injunction. Big news, as I've just outlined. Judge Cooper ruling that Musk and DOGE today is subject to the Freedom of Information Act request so that the information about them spills out into the open where we operate. We're supposed to operate government in the sunshine being the best disinfectant. And now Judge Cooper has taken a can opener to get inside of this issue. While on the other side, in another case down the hall, Judge Chutkan has just ruled that Elon Musk must give sworn testimony under oath. That's the big headline here. I'll continue to follow it all right here on Legal AF. Thanks for being here. Thanks for being part of our 500,000 subscriber odometer turn. We just got there today. I'm so excited, and I'm humbled by it as well. So until my next reporting, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.